I tried to open my garage yesterday and it was frozen. It was like frozen shut. My husband was afraid the garage door was going to break. But
Oh
luckily it did.
no.
We were able to get out because we had to go, my husband had to go plug up his truck because it's got a battery. It's a diesel, so he
Hmm.
had to go start it to get it ready in case he had to go to work today, which he didn't have to, thank God. But he was like freaking out because he was like, "Oh God, I think I'm gonna break the garage trying to open it."
Yeah. Yeah, you
And
just
would have experience.
oh, it is freezing. I have a question. Attorney Harper, your name, it has a cause number of DF23, but I'm seeing DF25.
It is. It's 2.5. I'm sorry.
Okay. No, that's fine.
That was that was my mistake. I think I just noticed that.
Okay. I wanted to make sure I was on the right case because
You
everybody
are.
else
I was. Yeah. I'm
five.
Yeah, the
sorry.
right.
Okay. And good morning, Attorney Franklin. How are you?
I'm doing well. How are you doing?
Good. Right. All right. So for this case, I have one, two, three, four. I have four exhibits for the husband. And then for respondent wife, I have two exhibits. Is that correct?
Yes, she's the respondent in this motion, but she was the petitioner in the original matter.
Okay. You have, let me see. One, two, three. Yes, four. And all right, both sides ready to proceed. Does the state have anything?
Judge, we didn't submit anything. We were noticed to be here because we intervened in the divorce, but we didn't file any pleadings or anything.
Okay. All right. No problem.
When did you intervene into the divorce? They don't have any children together.
I was about to ask that question.
I didn't
On
see
the
anything.
You're on the wrong case.
Oh, I'm sorry. This is not the
Oh
McCormick
Lord
case.
Jesus, you scared me to death.
I was like,
I was thinking to myself, is there something I don't know about? I'm like,
I was like,
Oh,
that
this is
is
the
that's
matter.
okay. Okay, you almost gave me a
No,
heart attack, but that's okay.
no, you, Attorney Franklin, you almost gave all of us a heart attack. I'm like, wait,
I
what?
think my client the most, right? Because she was like, I had a kid I didn't know about.
Sorry, y'all. Sorry.
That's okay.
But it was good to see you anyway.
You too, Judge. So that one is this afternoon. I just wanted to make sure.
No,
Okay. So sorry, y'all. Not being
no,
no
yes, have a good
problem.
rest of the day.
okay. You too. Y'all stay warm.
Thank you, you too. All right, both sides ready to proceed?
Yes, Your Honor.
Yes.
All right, Joey, you ready?
I'm ready, Judge. Go ahead. Thank
Okay, we're on the record in cause number DF2508117. Councils, will you please announce for the record?
Vincent appearing for the movement, Juan Arriaga.
Danielle Cortez Harper, appearing for the respondent in the motion for new trial, Yolanda Alvarado now. Previously,
All right.
Yolanda Arriaga.
All right, with those who intend to testify, please raise your right hands. Do you all swear or affirm? Oh, I don't see your hands.
I'm sorry. Can you see it right there?
Yes, and Mr. McCormick, raise your right hand.
Is this still the case for Aaron and Yana McCormick?
Oh, yeah, you're not, yeah, no. You can log off with the state. They've already left. I'm sorry.
Oh, okay. So it's been rescheduled or what am I doing?
You know what? That question, it's not on my docket. It's possible you may be on Judge Lee's docket.
Per the case file, the hearing that they had scheduled today was removed because there was no exhibit conference.
Oh, you all didn't have an exhibit conference. So you're going to email the my coordinator. Do you have her email address?
Is that Brittany?
Yes.
Yes.
Okay. So you're going to email her and then she's going to get you all reset with a date for an exhibit conference.
Okay. All right.
My
Thank you.
apologies.
Okay.
All right. Okay. Now, ma'am, raise your right hand. Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes, I do.
Thank you both. All right. So we're set here for today on a motion for new trial. This was a divorce and a default judgment was granted. And the movement has filed a motion for new trial. Prior to going on the record, you all had an exhibit conference and some exhibits were pre-admitted. They will be admitted at this time. So movements exhibits 1 through 4 are admitted and respondents exhibits 1 through 2 are admitted. Did I get that right, councils?
Yes, Your Honor.
I'm sorry.
Okay.
Yes.
All right. So I have you all set at 15 minutes aside. That will include any opening and closing statements should you all choose to make one, as well as any examination of your witnesses. Attorney Nduwe, at this time, would you like to make an opening statement?
Yes, Your Honor.
All right, you may proceed.
Your Honor, may I please the court. My client is incarcerated in Oklahoma. So he's not here now. He's supposed to be here. He's supposed to appear by Zoom, but he called me and told me that the court is closed there, that they won't open until Wednesday. So I have his sister here. Okay. These people, according to their own pleading, they were married in 2015. Okay. And as strange as it might sound, this marriage was when my client was in jail. So my client was locked up in 2012. So the respondent came to the prison and married my client 3 years later, which would be 2015. My client was not released from prison until 2019. And I will tell you why this data are important. Okay. Subsequent to that, my client was arrested again in April 2025. He was arrested in Oklahoma for the charge in Texas, and he was brought back to Oklahoma 2 days later in April of 2025. My client was locked up in jail in Texas from April 2025 until September 2025 when he was moved back.
Hold on, Attorney and Duke, you're going in and out.
Okay. Okay.
Yeah, I'm going to object to him testifying as to facts. There's no affidavit attached to.
I'm giving
this.
the court general, but I can call your client testify.
Okay, but he's not there. You just said he's not there.
Counsel, I'm making an opening statement.
Okay.
It's not
But I'm objecting because you're stating facts that are not supported by an affidavit. A motion for new trial must be supported. If it's going to go outside the record,
No,
it must be
true.
supported by an affidavit. That is true.
Okay,
That's
so
true.
you all are not going to argue back and forth and speak over each other. She's making an objection. From what I'm gathering is that you're testifying to facts that are not in evidence. And this is your opening statement. So I'm going to sustain her objection and just state what your evidence is going to show.
Okay. My evidence will show that my client was locked up in 2012 and he was released in 2019. And they were married in 2015 in the prison. So, subsequent to that, evidence will show that my client was arrested again in April 2025 and was brought back to Texas. And he wasn't found in Texas until September 2025 when they moved him back to Oklahoma. And also evidence, exhibit number 2, will show that this property, one of this property involved, was purchased in 2009, which was years before he married my client. So this is a separate property that was awarded to the respondent. And they will try to tell you, oh, there was a
And again, as to him
I'm making
stating facts that are not into evidence.
I hope, Judge, you're not counting my time against me because I'm telling you what evidence we show.
Okay, so when you're Attorney and Duke, I don't know what's going on with your microphone, but it's going in and out. So I'm not even catching everything that you're saying. But just tell me specifically what your evidence, the evidence that you submitted, submitted, just tell me what it's going to say.
Exhibit number 2, which is the deed, we show that the property was purchased in 2009, which will be about 7 or 8 years before the marriage. And their own evidence, exhibit number 2, they will try to fool the court. It will show that there was a deed of trust for the same property in 2017. And as I told you, it was notarized. And this is the time period my client was in jail because he was released in 2019. So our contention was that deed we showed that was signed allegedly in 2017, deed of trust, was forged. It's not my client's signature. He can't notarize something from jail. Okay. Thirdly, exhibit number 1. You can hear me. Is it still cutting off?
No, I can hear you. I'm just taking notes. Okay.
Exhibit number 2, which is most important of evidence in this case, it will show that that my client was never served. If you look under 1, 2, 3, 4, line 5, we show it was served. The petition for the divorce, that the basis of this lawsuit was served an officer, Angela Palacio. Well, I checked in the court system. There is no order for substitute service. So that allows somebody else to be served on behalf of my client. But Judge, but more shocking, my client wasn't even in Oklahoma in June 2025. My client was in Texas. So how can somebody who is in Texas be served in Oklahoma? Number one. Second one, even if he's in Oklahoma, there is no substitute order that allow my client to be served through Angela Palacio. So my client was not served. So if my client wasn't served, The court have no to enter a judgment.
Vincent, what are you doing?
Can't-
Every time
we
you do
can't
that,
hear
like
you.
the last sentence, I couldn't hear you. It's like you're muffling over the microphone or something.
Can you hear me now? Okay.
Yeah,
I
don't
said-
touch anything. Just
Okay,
be
so-
still.
I was saying, well, my client was in Texas in June 2025, and they're claiming that he was serving in Oklahoma. That's impossible. He cannot be in two places at the same time. But let's pretend for the argument that he was indeed in Oklahoma. If you look on the exhibit number 1, it was served on somebody, Angela Palacio. My client is not Angela Palacio, and there is no order for substitute service that allow my client to be served through Angela Palacio. So it means that the default judgment they obtained is defective. The court have no jurisdiction to enter a judgment against my client. Therefore, I cited, since we have only 15 minutes, I cited the case law in my motion for new trial that does not allow a court to judgment when somebody is not served. So my client wasn't served. As the court.
We can't hear you. Went
Okay,
out.
can you hear
Court
now?
cannot not allow someone to be served.
The court cannot allow a judgment to be obtained on somebody that was never served. So we ask the court to set the judgment aside and grant my client a new trial.
Thank
Now,
you.
my witness.
Excuse me, I would like to make an opening
What-
statement as well.
I didn't hear what you said, Attorney Ndukwe, but it's
He said he
Attorney
was gonna,
Harper.
yes, thank you, Your Honor. And I'll try
Go
not
ahead.
to yell. I'm not mad at you.
I'm sorry,
Um,
I'm just in yet. I apologize.
Your Honor, first of all, I would like to tell the court that the motion for new trial and the first amended motion for new trial are procedurally defective. Motion for new trial based on matters outside of the record must be supported by affidavits or other competent evidence. This one is not. There is no verification. There are no affidavits. There is no testimony. There's just argument. They allege non-service, lack of notice, mistake or accident, pregnancy, and separate property. Every one of those is an fact. Without evidence, the court cannot grant relief. Even assuming these facts were true, Your Honor, the court has no evidence before it to consider them. Again, there is no affidavit, there's no verification, and even the movement on the motion for new trial is not present. However, even if he was present, there should have been an affidavit of verification attached to the motion, considering they are claiming several grounds for a motion for new trial that are outside the record. And I'm not going to go into that in any more detail. However, with regards to the service arguments, Your Honor, to challenge service based on facts outside the record, defendant must present evidence. They did not. The return of service is in the record. The motion does not rebut it with competent proof. The return of service itself is prima facie evidence that the service was sufficient. I'm sure I'm not going to have to go into too much detail about this, but according to Civil Practices and Remedy Code 17.029, the burden is not on Ms. Alvarado to prove the warden's designation unless and until the return is rebutted with competent evidence. And why I'm referring to Civil Practices and Remedies Code 17.029 is that lays out the service of an inmate who's in prison. And so the process server in this case does not require a substitute service. Each warden can designate the person who is going to accept service on behalf of an inmate. And in this case, that was Ms. Palacios, who is listed in the affidavit that is on file with the court. And at this time, I'd like the court to take judicial notice of the court's file and all its pleadings.
Court takes judicial notice of the court's file.
Right. Anyway, but with regards to that, the court does not add requirements that the legislator does, Dallas County courts, and even the Court of Appeals and the Texas Supreme Court rely on if service compliant is in compliance with the statute, due process is satisfied. There is no hand-to-hand receipt is not required for prisoners who are in jail under Civil Practice Remedy Code 7.029. That's why the steps are in there for service on a inmate, which the process was followed in this motion. Again, there's no magic words that have to be added into the return of service that say that there was hand-to-hand service of the document. And so for him to argue that there was no service and that substitute service was required, that is simply not true. And there is no family code statute that makes that requirement more stringent. as well. In Harvey versus State, service on an inmate is valid when citation is delivered to the person designated by the officer in charge of the correctional facility as authorized by Texas Civil Procedure and Remedies Code 17.029. Personal hand-to-hand service on an inmate is not required. Again, that's Hall versus State, 14 Southwest 3D 844. There's another case out there, Henderson versus Department of Public Safety, 879 Southwest 2D 873. Service is effective when made in the manner authorized by statute. Actual receipt by the defendant is not required when statutory service requirements are not met. Opposing counsel is bringing up that there was no order for substitute service. Again, I would point out to the court that there are no affidavits on file making these allegations of defective service, which lack of notice and lack of proper service is something outside of the record and must be verified with an affidavit. With regards to our Exhibit 2, there's a deed that shows the property in question is community property. It lists the parties as husband and wife. So there's that. And again, this other person that he has brought to testify is outside of the record. And so, again, there's no affidavit stating that this person had personal knowledge of the facts that he is trying to allege today. And another thing, one more thing. Exhibit 1 is going to show that my client has incurred almost $9,000 in attorney's fees in executing the divorce and in defending her in this motion for new trial.
Thank you. Attorney Ndukwe, one thing I did notice about your motion is that it did not have an affidavit attached, and pursuant to the Texas Rules of Civil Procedure, I believe number 93, it specifically talks about verified pleadings, and a motion for new trial is a verified pleading, which will require you to have a verification affidavit attached to the motion. What is your response to that? Because I've reviewed the original one you filed as well as the amended one, and it does not have an affidavit attached.
Judge, to some degree, you're right. However, the motion for new trial, if you're testifying something outside what was pled, then you're required to verify it. The law does not say that every motion for new trial must be verified. It's not what it says. It says whatever thing you are contesting that is outside the record of the court, then it has to be verified. If you look on the exhibit we offered here, everything we offer here is part of the record. It's not outside the court record. Example, exhibit number 1. The opposing counsel is trying to mislead the court. He said, yeah, as long as in this citation show that it was served on the designated person, then it will be okay. Okay. Yeah, it's the same we're talking about here. He doesn't have somebody that will testify before this court that Angela Palacio was a designated person to receive this service. She's trying to run away from the substitute order. So the statute she's quoting is misrepresenting what he said. He said, yes, if it was served on the person that was designated, is he telling this court there is somebody here to testify that Angela Palacio was the person that was designated to receive the petition? The answer is no, unless you will show me. I have looked on people who have logged in. There's none of them. And more importantly, as I told you, if you discount the fact that my client wasn't even in Oklahoma to begin with, because he wasn't verified, but that's where I want the court to zero in. So he wasn't in Oklahoma. He was here in Texas. So if you even discount that, if you go to exhibit that was part of this thing, including their own exhibit, which is exhibit number 2, the property was purchased in 2009. Remember, all we have to show in a motion for new trial is not to prove that everything that we're saying is true, is that we have a defense. If we are raising a meritorious defense, that this is a separate property, that alone is enough for the court to grant a motion for new trial.
Well, we first have to get there, and I don't believe we can get there without the verification. Do you have any case law that allows me to proceed on a motion for new trial for information, as you stated, that's outside the record, that would allow me to move forward with the motion for new trial with no affidavit attached?
Absolutely. I don't have it here with me, but I can provide with you. I can provide to you. So this is not a file.
We're here today.
Yes.
Can you respond to his argument, please? Just so I have it on the record.
Sure.
Allow me to finish.
Hold on, Attorney Ndukwe. Go ahead, Attorney Harper.
Thank you. Your Honor, again, it's not my client's responsibility to show, again, let me strike that. The return of citation on its face is enough to establish that the respondent, Mr. Arriaga, the respondent in the divorce was served properly. My client doesn't have a burden after that. He's the one claiming that service was defective. Therefore, the burden shifts to him to argue that, which he's making that oral argument today. However, that doesn't negate the fact that he was required to attach a verified affidavit on his motion. And if you look at his motion for new trial, he doesn't even bring up anywhere in his motion that Mr. Arriaga was not in the state of Oklahoma at the time that he allegedly served. Now, even if he had put that in there, he still did not have any evidence attached to show that service was defective or a verified pleading. So again, my client does not have the burden to prove, because the court has to take the return of citation as valid on its face. So the burden shifts to him, and he has not produced that anywhere. I mean, it probably wouldn't have been that difficult to get something from the warden of the prison to show who was the actual designated person to receive citations on behalf of the jail, and that could have been attached if there was a business records affidavit, or their testimony could have been secured for today's hearing. And so I just wanted to point that out to the court.
Sure.
Okay. I also asked the court to take a judicial notice of the final decree of divorce, which is number 3. If you look on that is number 3 alone, there are 4 properties involved. She was awarded the entire property. There's nothing testimony. I have the one of the is number 4, which is transcript. There's nothing in the record that show that she testified that this is fair and just division. If you take her argument that you discount our exhibit number 2, which is a separate property. If you disregard that, then there's no testimony there that show that if you agree with them that this is a community property, that our exhibit number 2, which show that is a separate property. If you discount that, there's no testimony on exhibit 4, which is a transcript that show that there was a testimony that this is a fair and right division of the community property, that she should be awarded 100% of the 4 properties. Just pretend that it was a community property, that it wasn't a separate property. There's no testimony on the record, on that transcript, exhibit number 4, which is part of the record she's talking about. Nothing there suggested remotely that it was fair and just for her to be given 100% of the 4 property, which we claim to be separate property. What she claims is community. There's nothing in that testimony. The law requires the court to make a finding that is fair and just in the division of property. There's nothing there. Testimony, I have the transcript. I offer it, which is already been admitted as case number 4. There's nothing there that shows it was fair and just, that she be given 100% of what the property she claimed to be community property. So it is part of what we raise as a meritorious defense. How, as the court, there are too many grounds. If you discount, she was properly served, then the court should consider that the court awarded her 100% of the 4 property, and there's no supporting testimony. I have the decree and the transcript that show it was fair and just that she be given 100% of the property. So I will ask the court, that's another ground for the court to grant a motion for new trial.
Your Honor,
So you don't even have to. So even if your arguments were valid, Attorney Ndukwe, without this pleading being verified, which is required by the law, and I haven't come across any case law that allows me to circumvent the law when it talks about a verification being required, because TRCP 93 actually says that it is a required shall. There is no exception to that. I can't even hear any of the evidence about whether or not it was a just and right division. I can't even get there. So the court denies the motion for new trial.
Okay.
And
thank
you all.
Can I put my client? Oh, okay. Can I ask for
Yeah.
my client for attorney's fees? Can I call her as a witness?
Yes.
Okay, thank you. I would call Yolanda Alvarado, formerly Arriaga.
Yes, you may proceed.
Judge, I'm going to object for a simple reason. There was no pleading. She didn't find a response to motion for the new trial. Therefore, I'm entitled. Allow me to finish, counsel. I'm entitled to be, according to Rule 21 and 21A of Rule of Civil Procedure, I'm entitled to a fair notice. There's nothing here. He filed no motion. He filed no response. That she's going to be asking for attorney. So I'm going to object. What would be the basis for her to even testify on attorney's fee?
May I respond, Your Honor?
Yes.
So my client's not required to file a response to the motion for new trial. The case was over. He's trying to open up the new case. He's trying to open up the case again. Also, we had an exhibit hearing and he did not object to my exhibit regarding attorney's fees, which is exhibit 1. And so my client, I think, should be able to testify as to the fees incurred.
Judge, exhibit is not a pleading.
Pleading.
Exhibit is not a
To
pleading. You have to
attorney's
have a
fees.
You cannot ask, you cannot guess something you didn't ask. The way you
Your Honor,
ask something from the court, you have to file a motion or file a response. It's like somebody file a petition, you file a general answer. You cannot be, there's no request you're making. You didn't
Can
even
you,
file
can you please talk without
Hold
yelling?
on, Attorney Ndukwe, I know you said that, you know, I'm taking it as passion, right? But you do not have to yell at any of us.
I apologize. I wasn't yelling. That's not what I meant.
I understand, but yeah, just calm down a little bit.
Okay,
Thank
Judge, my
you.
point was, she filed no motion. I'm entitled to be given notice, fair notice that she's gonna be asking for attorney's fee today. There's no motion to put me on notice. There's no response to put me on notice. Just filing, submitting an affidavit. It's not enough. Affidavit doesn't get you there. What get you there is the pleading. Just as you can't have it both ways. You're making an argument. Oh, the motion for new trial is defective, therefore you cannot hear it. Now, at the same time, you are trying to testify on attorney's fee when you have no motion. There's nothing to give me a fair notice to prepare myself to defend on your request for attorney. I'm objecting for her testifying on that.
Okay, Attorney Harper, did you file an answer with the request for?
Let me check my,
You couldn't have filed one because
I think I filed a notice of appearance, Your Honor. Let me make sure though. Hold on. I have one more place to check. I'm sorry.
Okay, you're okay. Now if in her notice of appearance, she put a request in there for attorney's fees, then the court can proceed with that. But Attorney Ndukwe, if you're saying it happened, then we already know.
To be honest with you,
right.
I was just, to be honest with you, I'm gonna not request the attorney's fees because I had anticipated, I didn't know what to expect today, so I had put on my exhibit for attorney's fees in case you granted it, because it is in the normal course for attorney's fees to be granted if a motion for new trial was granted. But since you denied that, I think my client's gonna be happy with. I did not file a request for attorney's fees for today, so I will not call my client as a witness, and I will promptly get you an order denying the motion for new trial.
If you could get that to me today, I will sign it.
I sure will. I will get it to you today. Thank you. Are we excused? Okay.
Thank you,
Yeah.
Judge.
Thank you.
Good day.
Thank
You
you,
too.
Judge.
You're welcome. You're welcome.